In the matter of Ashok Kumar Jain versus the state of Gujarat, Supreme Court allowed the appeal, set aside impugned order, and quashed the FIR. The respondent number 2 in this case complained that the appellant, after appropriating goods exported, had not paid sale price of rupees 34,71,344. MS Oswal Overseas was the exporter and primary liability for goods entrusted lied with the appellant. Respondent 2 had treated director or partner of MS Oswal Overseas as witness to bring home accusation of breach of trust and cheating. Court said that we do not want to hold a mini trial and observe whether such an effort, either in course of investigation by police or finally in prosecution, will bring home aforesaid charges. In documents filed, which was a true copy as Annexure P2, invoices and payment of receipt made by appellant were shown as consignee and MS Oswal Overseas as exporter. Therefore, court said that the entrustment was made to MS Overseas by respondent number 2 and not to the appellant. The sale price was agreed to be debited to the account of MS Oswal Overseas, accepted the same as part payment against subject export of goods from appellant. Court said it might be true that appellant was yet to discharge sale price of subject export. Respondent 2, by referring to oral arrangement of inducement, tried to plead the case contrary to documents through which final entrustment of exported goods happened in Sri Lanka. For above reasons and particularly appreciating the annexures, court was of the view that continuation of FIR against appellant was abuse of process of law and at best the non-payment of sale price could be a civil dispute between appellant and MS Oswal Overseas. While referring to the case of State of Odisha versus Pratima Mohanty, court said that as per settled proposition of law, while examining an FIR or a complaint, quashing of which is sought, court cannot embark upon any inquiry as to reliability or genuineness of allegations made in FIR or complaint. Quashing a complaint or FIR should be an exception rather than ordinary rule. The powers under Section 482 are very wide, but the conferment of wide power requires the court to be more cautious. It casts an onerous and more diligent duty on the court. While referring to Kaptan Singh versus the state of Uttar Pradesh, court said that the inherent jurisdiction under Section 482 of the code, though wide, is to be exercised sparingly, carefully, and with caution. Only when such exercise is justified by tests specifically laid down in the section itself. Further appreciation of evidence is not permissible at this stage. While referring to Pratibha versus Rameshwari Devi case, court said that it is not open to High Court to rely upon report of investigating agency, nor can it direct report to be submitted before it, as law is very clear that report of investigating agency may be accepted by the magistrate or the magistrate may reject the same on consideration of material on record. Such being the position, report of investigating agency cannot be relied upon by High Court while exercising powers under Section 482 of the Court. The court, while discussing expression entrustment in Rashmi Kumar versus Mahesh Kumar Bhada, observed that it carries with it implication that the person handing over any property or on whose behalf that property is handed over to another continues to be its owner. Entrustment is not necessarily a term of law. It may have different implications in different contexts. In its more general significance, all its imports is handing over the possession for some purpose which may not imply conferment of any proprietary right therein. The ownership or beneficial interest in property in respect of which criminal breach of trust is alleged to have committed must be in some person other than accused, and the latter must hold it on account of some person or in some way for his benefit.